there, my friends. Welcome to those of you watching us for the first time. And to those of you already sharing this journey with the Academy, thank you so much for joining me again. Here we're exploring international law. The two playlists mentioned above are the paths that we have took so far, and I am here to take it further by drawing the law alive. We are talking about subjects of international law, which you can revisit the created videos about that in my playlist above. And today, we're continuing our discussion about international organizations in international law. Ready your curiosity, and let's begin this new chapter together. Having explored the state as the first and most fundamental subject of international law, we now turn to the second key subject, the international organization. When we step into the world of international organizations, we must begin with the simplest, yet most essential question. What is an organization at all? What do we mean by an organization in the first place? At its core, an organization is a voluntary assembly of actors, structured to achieve objectives that no individual alone could accomplish. It is cooperation made tangible, a framework where intent meets structure, and collective action becomes visible. When this concept extends beyond a single state, we arrive at the international organization. In international law, an international organization is defined as a voluntary assembly of states created through an international agreement with permanent and independent organs, empowered to make decisions autonomously, and endowed with a legal personality distinct from its members. Its primary purpose is to safeguard the common interests of its member states, and its existence is based on a founding treaty or charter. Importantly, the essence of an international organization lies in its charter and its functioning, not simply in the presence of state representatives. There are three essential elements in this definition. First, the foundational element, the founding treaty or charter, which embodies the collective will of states to cooperate, though it may not always be a formal treaty. Second, the institutional element, a permanent and structured organizational framework that ensures continuity, stability, and governance. Third, the functional or instrumental element, the organs, powers, and tools that allow the organization to fulfill its objectives and carry out its mandates. The key characteristics of an international organization are clear. It is intergovernmental, involving multiple states, though some organizations may exist as subunits within larger ones. It has a permanent independent structure with organs capable of functioning autonomously from individual member states. And it is based on an international agreement reflecting the collective intent of the states and is established through a founding charter. So, in essence, an international organization is a grouped institutional assembly of states created to achieve specific shared objectives, formalized through a founding document, and functioning with a legal personality and powers that transcend the mere presence of its members. To understand why international organizations exist in international law today, we must journey back through history, tracing the path that led states to create structured, cooperative institutions. Our story begins in ancient Greece, where the first forms of organized cooperation emerged. The earliest organizations were amphictyonies, sacred leagues of city-states tasked with regulating relations around religious sites and coordinating collective responsibilities. By the 5th century BCE, confederations appeared, such as the Arcadian League and the Boeotian League, where decision-making and voting reflected both cooperation and power dynamics. Among these, the Peloponnesian League, led by Sparta, stood out for its strength and influence. Later, the Cretan League acted as a military council, and after Greek victories over Persia, the Athenian Confederation emerged to ensure collective security and coordinate binding military treaties. These early confederations represent humanity's first experiments in organized interstate cooperation. Organized cooperation took new forms during the medieval period. Cities, kingdoms, and trading powers developed early international structures to manage commerce, security, and shared interests. The Hanseatic League, a network of northern European cities, coordinated trade routes, regulated markets, and provided collective defense. Dynastic alliances across kingdoms ensured mutual protection, while the Swiss Confederation exemplified early state cooperation for defense and governance. Even religiously inspired leagues shaped political and social order, blending moral authority with practical coordination. These medieval arrangements were not international organizations in the modern legal sense, but they laid the conceptual and functional foundations for structured cooperation among political entities, showing that the need for organized collaboration transcends time, geography, and culture. The 19th century brought new dimensions. After the Napoleonic Wars, political organizations emerged to maintain peace and order in Europe. The Holy Alliance and the Congress of Vienna coordinated between great powers, while the European Directorate, established by the Treaty of Paris, implemented collective decisions, most importantly through Article 6, which defined coordination among powers and extended authority over France. Additional protocols, like those of Aix-la-Chapelle, solidified commitments of 5 major powers to preserve public order, forming a semi-institutional structure that applied across Europe and beyond. Alongside political organizations, technical and functional cooperation developed as international relations expanded. After the Industrial Revolution, states required collaboration in areas less political and more technical. Early river commissions like the Rhine Commission, Alba Commission, and Douro Commission coordinated cross-border administration. At the same time, international unions emerged: the International Telegraph Union, the International Postal Union, and early organizations for standardizing trade and shipping. These were the first modern prototypes of international organizations focused on practical cooperation. The early 20th century saw profound change. World War I revealed the limits of informal or technical cooperation. The League of Nations was created to maintain peace, mediate disputes, and prevent war. It represented a new political and legal model: organizations with a global mandate, permanent organs, and the authority to act collectively. The mid-20th century followed the devastation of World War II. The United Nations and its specialized agencies formalized legal personality for organizations, expanded responsibilities to include humanitarian aid, economic reconstruction and security, and institutionalized collective decision-making. The UN embodied a new understanding of international organizations as indispensable subjects of international law. But from the late 20th century to today, international organizations have diversified further. Regional organizations like the European Union, ASEAN, and the African Union coordinate political, economic, and social objectives. Specialized agencies such as WHO, UNESCO, the World Bank, and many others focus on functional areas, while a complex web of treaties and cooperative arrangements connects states across domains of trade, environment, health, and security. Looking at history broadly, scholars often classify international organizations into 4 generations. 1. Early technical commissions, river commissions, and small cross-border administrative bodies. 2. Functional international unions, postal, telegraph, trade, and standardization unions of the 19th century. 3. Post-war political organizations, League of Nations, UN, and other global institutions with collective security mandates. And 4. Modern international organizations, regional, specialized, and functional bodies formed to meet evolving needs, including crises, security, development, and transnational cooperation. Through all these stages, international organizations adapted to the needs of the global community, evolving from simple technical coordination to complex political, social, and economic governance. They have now established themselves as distinct subjects of international law, reflecting centuries of experimentation, innovation, and legal recognition. The emergence and expansion of international organizations have always been shaped by a combination of encouraging forces and obstacles. On one hand, political factors drive states to cooperate: the fear of war, the need to prevent colonial domination, or the desire to stabilize regional and global security. Economic factors also play a role: the pursuit of scientific progress, the management of trade and resources, or the correction of economic imbalances can all foster collaboration. In addition, shared global challenges, from environmental concerns to public health crises, create natural incentives for states to form structured, cooperative institutions. Yet, just as forces encourage expansion, obstacles can hinder it. Deep-seated nationalism or unilateralism may prevent states from pooling authority. Inequality among states, conflicting interests, or divergent political and legal theories can block consensus, stalling the creation or growth of organizations. In essence, the development of international organizations reflects a dynamic balance. They expand when shared needs, mutual interests, and collective vision align, and they stagnate when disagreements, inequalities, or conflicting priorities dominate. The history of these organizations is therefore a story of both human cooperation and the challenges inherent in balancing sovereignty with collective action. Understanding how an international organization is created is one of the most fascinating parts of international law, as it shows how the international community emerges from the free will of states. In international law, the right of states to create international organizations is a customary right, meaning that states are free to come together, establish a new institution, and define its personality, structure, and purpose. This freedom is the foundation of the diversity and variety of international organizations in the world. Organizations can be created in different ways. The most common method is through the conclusion of a founding treaty, which may be initiated by one or more states. For example, Italy invited multiple countries to participate in an international conference to conclude the founding treaty of certain institutions. Another important method is the establishment of organizations through international conferences. These conferences may be convened to draft a founding treaty or to collect information and negotiate the creation of a new organization. A classic example is the Bern Conference, which, before the creation of the International Labor Organization, adopted two important conventions that laid the institutional groundwork. Sometimes, however, conferences do not succeed in establishing an organization, and the participating states adopt guiding principles or temporary arrangements instead, such as GATT after the 1948 conference, which eventually led to the World Trade Organization. Conferences may also prepare a draft founding document, as in the case of the Dumbarton Oaks Conference for the creation of the United Nations. In some cases, existing organizations collaborate or use joint agreements to establish a new organization. Founding documents are not always treaties. Sometimes a resolution acts as the founding instrument, like ASEAN, or a conference declaration serves this purpose, such as the final act of the Helsinki Conference. Even non-international governmental bodies can create an organization, like the Nordic Council. Additionally, a resolution of another organization may establish a new organization. A notable example is UNICEF, created by a resolution of the UN General Assembly. The creation process is not always linear. Sometimes an entity exists for years before obtaining a formal statute. For example, the Organization of American States began as the Pan American Union, and 60 years later, the Bogota Charter formalized its structure. Conversely, a cooperative process may initially lack the intention of creating a formal organization, like the Conference on Security and Cooperation in Europe, which later became the Organization for Security and Cooperation in Europe, OSCE, through the Paris Charter. Thus, the history of international law shows that organizations are the product of political developments, collective needs, successes, failures, and shared experiences of states. Any path, method, or document that makes cooperation durable can bring a new international organization into being. Meanwhile, the most important feature of international organizations is their voluntary nature. States are not automatically bound to participate. Rather, their cooperation is based on free will. This principle of voluntary participation gives rise to several essential freedoms. States have the freedom to decide whether to join an organization or not, the freedom to withdraw if they no longer wish to participate, and the freedom to accept or reject certain responsibilities or mandates within the organization. Additionally, organizations may allow for temporary suspension of voting rights or even expulsion of members, reflecting the fundamental idea that membership is voluntary. This voluntary character ensures that international organizations function as platforms for cooperation among sovereign states, rather than as coercive bodies. It emphasizes the legal and political independence of each member state, highlighting one of the core principles of international law and the essence of international organizations themselves. Once the founding document is completed and an international organization comes into existence, it immediately takes on a structured form to ensure it can function effectively and fulfill its purposes. The structure of an international organization is typically shaped by its founding treaty or charter, and it varies depending on the organization's goals, scope, and membership. At its core, an international organization usually has permanent organs or bodies. These organs may include legislative, executive, and sometimes judicial branches or specialized committees, depending on the organization's mandate. Some organizations also have administrative secretariats that manage daily operations, maintain records, and coordinate activities. The organization often has its own budget and financial system, which may be contributed by member states or generated through specific activities. This allows for operational independence and ensures that the organization is not fully dependent on a single state for resources. Legal personality is another key feature. Many international organizations possess independent legal personality, which allows them to enter into agreements, own property, and bring claims or be sued in their own name, separate from their member states. However, not all organizations have this status. Some operate more as coordinative bodies without independent legal personality. International organizations also enjoy varying degrees of autonomy and self-governance. They can make decisions through their own organs, implement programs, and exercise certain powers within the limits of their mandate. The responsibility of the organization itself may also be defined in the founding document or international law, delineating what it can or cannot do. In short, the structural features of an international organization include permanent organs, administrative bodies, financial independence, legal personality, decision-making autonomy, and defined responsibilities. These elements allow the organization to function as a coherent, independent actor within the international system, capable of achieving the collective goals of its member states. Just as an international organization is created, it can also come to an end, and its termination can take several forms depending on the circumstances. One form is succession, where one organization replaces another. A classic example is the United Nations succeeding the League of Nations. Succession can also occur due to specific conditions, such as the collapse of the Eastern Bloc, which led to the dissolution of certain regional organizations, or the end of the European Economic Community structures in Eastern Europe. Sometimes, an organization is created with a fixed duration from the beginning. For instance, the European Coal and Steel Community was designed to exist only for a limited period. In other cases, termination may result from financial or operational conditions where the organization can no longer function due to lack of resources or support. Similarly, certain organizations may end because of regional conflicts or crises, like the East African Community, which dissolved after the war between Uganda and Tanzania. Termination can also occur when an organization's original purpose is fulfilled, making its continued existence unnecessary. For example, some joint African or regional organizations ended once their objectives were achieved. We also should be aware of dissolution. Dissolution can be partial or complete. In a partial sense, certain functions or assets of an organization may be transferred while other parts continue, such as the European Union and European financial institutions, or the International Telegraph and Postal Unions, which underwent partial restructuring. In a complete sense, the entire organization ceases to exist, as happened with some older specialized international organizations that were fully dissolved. Thus, the end of an international organization is not a uniform process. It can happen through succession, fulfillment of objectives, fixed duration, financial or operational failure, or regional crises, and may be either partial or total, reflecting the dynamic nature of international cooperation over time. In any case, from the moment an international organization comes into existence and throughout its life, it possesses rights under international law. These rights are recognized as part of the body of international law governing international organizations. This area of law remains incomplete and developing. as a fully coherent theoretical framework concerning the nature, legal personality, powers, and responsibilities of international organizations has not yet been fully established. The law of international organizations has both specific and general dimensions. It is specific when considering the internal relationships between the organization and its member states, regulating rights, duties, and governance within the organization. It is general when applied externally, in relation to other subjects of international law, where either general international law or specialized rules are applicable to the organization as a distinct actor. The detailed discussion of the rights, powers, and legal framework of international organizations will be addressed in a separate, dedicated series. Today, our focus was on introducing the organization as a subject of international law, highlighting its essential features and significance. The deeper exploration of its rights and legal personality as a distinct subject will follow later on Academy's journey. With all of that said, you should know this. When we study international organizations, it is essential to understand both the criteria by which they can be classified and the different types of organizations that exist. This helps us see why organizations are created, how they operate, and how they differ from one another. First, let's talk about the criteria for classifying international organizations. Based on geographic or demographic scope, some organizations are universal, like the United Nations, while others are regional, like ASEAN or the European Union. Some may also consider ethnic, cultural, or ideological characteristics in membership or focus. Based on subject or work area, organizations can be distinguished by the issues they address. Some focus on political coordination, others on economic cooperation, technical standards, cultural exchange, or scientific research. Based on purpose or objectives, some organizations exist to promote peace, security, or regional stability, while others coordinate technical, social, or economic cooperation among states. The objective shapes the organization's structure and functions. Based on competence or powers, broad competence organizations have extensive authority to act across multiple areas, often with binding decision-making powers, and limited or specialized competence organizations focus on a specific area or function, like technical or operational bodies. Based on structure and independence, some organizations are fully independent, with their own secretariats and legal personality. Others are dependent or subsidiary, administered by a member state, with limited autonomy. And finally, based on duration or permanence, organizations can be temporary or ad hoc, created for a limited purpose or period, or permanent with independent organs and continuous structure. Now, let's talk about the typology of international organizations, illustrating these classifications in practice. The very first one is the intergovernmental or international organizations, IGOs, created by treaties or agreements among states with independent legal personality, permanent organs, and authority to act on behalf of members. Non-governmental organizations, NGOs, are established by private individuals or entities under domestic law, not by treaties. They contribute to cooperation but do not exercise intergovernmental authority. We will turn to these organizations in another video and talk more about them, okay? Today, the focus is on intergovernmental ones. Then we have mixed intergovernmental and non-governmental organizations, combined state agreements, and private domestic participation, blending features of both intergovernmental and non-governmental organizations. Public political organizations have broad competence and authority, addressing political or strategic issues at regional or global levels. Council-type or consultative organizations, like the Council of Europe, provide forums for discussion, negotiation, and advisory functions, but are generally non-binding. Operational organizations are focused on practical and service-oriented functions, such as the International Coffee Organization or Cocoa Organization, carrying out programs for member states. Temporary or ad hoc intergovernmental organizations are established for specific projects, conferences, or limited periods, sometimes evolving into permanent entities. Finally, we have dependent or subsidiary organizations. Lacking independent secretariats, with administration delegated to a member state, some of these evolve into fully independent organizations. Now that you got familiar with types and typology of international organizations, you should distinguish international organizations from related entities that are not full international organizations as well. So consortia are alliances of private companies or entities, commercial or corporate, not intergovernmental. Treaty organs are created to monitor and supervise compliance with treaties, exist solely for treaty oversight, not broad cooperation. International courts are judicial bodies, such as the International Criminal Court. Independent organizations are focused on judicial authority, not general cooperation. And specialized UN agencies under ECOSOC, with internal and external legal personality, operate autonomously within their mandates. One important point to remember, despite all the differences in terminology, types of organizations, and their various meanings, is that international organizations have undergone a journey in their nature, from classical to modern forms. Classical international organizations in international law were often confederations. In these structures, states cooperated in certain fields without relinquishing their sovereignty, maintaining full control over their domestic affairs while collaborating within the framework of the organization. But over time, international organizations have become more modern and transnational. Modern international organizations often adopt federal-like structures, where part of the member state's sovereign powers is delegated to the organization to allow it to act effectively, implement policies, and carry out its objectives. This evolution toward a more integrated and empowered organization is a key concept to keep in mind. Okay, I think we're good for today, my friends. I hope you're enjoying this so far. Now that we understand the meaning of an international organization, along with its historical evolution and modern characteristics, we can move forward. In the next video, I will introduce some of the most famous international organizations as subjects of international law. So until then, take care of yourselves.